Good morning, Mr. Ali.
Good morning, Chief Justice.
Did I pronounce your name correctly?
Ali is correct.
Ali, all right.
I have cousins that say Ali, but I'm Ali.
Okay. I always worry. I don't like it when people mangle my name, which is the bane of African names. I see that you and I share a birth date, and I mentioned this because not many people are born. Well, I don't know. Maybe you're the third person I've come across who was born on that particular day. So I'm excited about that. Are you well?
Nervous,
Nervous,
Chief Justice.
but comfortable enough to
Yes.
start with the interview?
Yes.
All right, let's get to it then. You hold 2 degrees. You did a BA, then did an LLB.
That is correct, Chief Justice.
The BA at the University of the Western Cape.
That is correct, Chief
Then
Justice.
you went to Rhodes.
That is correct, Chief Justice.
You started out as a teacher.
Chief Justice, if you recall, in those days, we had bursaries, and in some way you had to pay back the bursary. My BA had teaching subjects, so I was able to teach as a category C, and then I returned to Rhodes to complete my LLB.
Oh, I see. What subjects did you teach?
Science, biology, and then the whole school vocational guidance.
Oh.
Because one of my majors at UWC was psychology.
All right. So you did that for 2 years?
That was from
1984?
84 to 86, so 3 years.
No, 3 years.
Yeah.
And you then decided to pick it up and become an advocate?
Yes, I returned to complete the LLB, which I completed, and then admitted in August of 89.
Okay. What did you practice as an advocate? Your questionnaire does not state. Sorry?
Gqeberha, formerly Port Elizabeth.
Port Elizabeth, all
Yes.
right. For 7 years.
Yes.
Then you left, and well, the Department of Education called you back.
Yes, Chief Justice.
And you worked there as a legal advisor for how long?
I left in 2001, so that is more or less 4 years, Chief Justice.
And then you left the Department of Education and joined the Secret Service.
Yes. As a legal advisor, and then later on a director in one of the departments.
And you remained there for 11 years.
Yes, because I returned to the bar in 2012.
In 2012.
Yes.
Yeah, and you are still there to date.
Yes.
Where? Here in Johannesburg?
Yes, Chief Justice.
Right. You mentioned in your application form that your practice centers mostly around personal injury law.
That was here in Johannesburg. Personal injury as well as public, in the sense of claims against the Minister of Police, where I acted for the state attorney.
Yeah. And you state that you have not done any administrative law work that involves administrative law, constitutional law, And the only areas of civil law you've worked in is divorce and personal injury law.
That is correct.
That is the case.
I do indicate later in the documentation that I dealt with those matters as an acting judge.
Yes,
But
yes, you
yes.
do. All right. You've acted intermittently since 2020, you say.
That is correct, Chief Justice.
And for how long do you total up those stints to?
It appears to be around 61 weeks.
And you've written judgments.
That is correct, Chief Justice.
Any idea how many those could be?
Chief Justice, it could be because of the nature of the proceedings that I presided over, it could be over 20,
Any reported?
none reported.
Okay. Well, I'll leave it to Judge President Mlambo to flesh out what kind of work you have done during your acting stints. What I want to ask you about are the reserve judgments you list in your application form. Have you delivered them yet?
Not all, Chief Justice.
Which ones have not been delivered?
The
You list them at page 15 of the bundle. Although one of the professional bodies says they found more, 3 more to
Yes.
add to your list.
The ones that are there now, Chief Justice, is at page 15 at 9.5. The one still outstanding is the one of Alexander.
Sorry, which one?
The first one,
The first one.
yes,
All right. The others have been delivered.
yes.
Okay. That judgment was reserved on 10 July last year. What has been going on there?
Yes, Chief Justice, this is one that has had me busy, and I'm trying to my best to deliver it, and I know I've said previously it will be delivered this time, that time, that time. But it must be done and will be done, Chief Justice.
When do you hope to have it delivered?
Well, finally, it must be done by the end of this month.
The end of October.
Yes. If it's if it's sooner, the better.
Yes. The worrisome thing, Advocate Ali, is that all these reserve judgments were reserved months ago. Well, when did you deliver Foster and Lebitze, which were reserved in August and October 2023?
Recently, Chief Justice, the dates I can't give you.
No, it's
At
fine,
the
but
moment.
you say recent. How
Yes.
recent?
It could be 2 months ago.
About 2 months ago.
Yes. But it was after the submission of the application.
Then the remaining 3 on your list were reserved in February, which is several months ago. Were they also delivered about 2 months ago?
I would think so, Chief Justice.
Yeah. Well, the General Counsel of the Bar reports that they found at least 9 outstanding judgments. So which are the other 3? Well, they say at least 9. They don't say 9, so there could be more. But let's focus ourselves on the three, the extra three. They specifically mention. Which judgments are those?
Chief Justice, I can't off the top of my head remember which ones those are in respect of, I thought the documentation of the General Bar Council would have been here, and I thought they would have but the ones, as I understood their comments and objections, it had to do with the length of time, as you have already also expressed, Chief Justice. But off the top of my head, I can't think of the other three.
Do you deny that there are more than the 6 you have listed? This is what I'm concerned about.
Oh, no, I don't.
You don't?
No.
But are you working on them?
Yes, Chief Justice.
This is extremely worrisome, Advocate Ali. You would be aware of the existence of norms and standards that enjoin judges to deliver judgments within 3 months of the hearing of the relevant matter, and certainly no later than 6 months from the hearing of the matter. And
Yes, Chief
here you
Justice.
are, you have a whole pile of late judgments, some over a year, by over a year. And now we have professional bodies. In fact, I want your comment to what the GCB, which I assume you remember of, it says it would send an acceptable message to the public at large if you are appointed. What would you say to that?
Chief
And
Justice.
they point out that the ability to deliver judgments expeditiously lies at the heart of dispensing justice.
Yes. Chief Justice, all I can indicate, I acknowledge, because it's factual what they say in terms of the delivery. All I can indicate is that it will be my endeavor, and it must be, that the judgments get delivered within the norms and standards policy.
What has been your challenge? Why have you delayed these judgments?
Chief Justice, in some instances it would have been, but it wouldn't have been that long. This is why in some instances it was an issue of ill health. In other issues, it's a matter of I type my own judgments, but to me that doesn't really necessarily explain away the fact of the lateness of the judgments, Chief Justice.
And what guarantee does the judiciary have that if you are appointed, you will not continue on this track?
Chief Justice, I can today then express myself to say that I would. And furthermore, the JP is a hard taskmaster in respect of matters of this nature.
Well, he has not been able to crack the whip hard enough, because here we are, hard taskmaster as he may be.
Yes, I accept that.
All right, thank you, Advocate Ali. I'll hand over to JP Mlambo.
Thank you, Chief Justice.
Thank you, Chief
Questions to you.
Justice. Good morning, Advocate Ali.
Good morning, JP.
Thank you for availing yourself. I just want to touch on a few issues. Let's start first with your exposure and familiarity to the work in the Gauteng Division. You've admitted you've acted for a period of 61 weeks totally.
Yes, JP.
And in that time, according to the spreadsheet in front of us, you've done 7 weeks in the opposed motion court.
Yes,
And you would agree with me that that's one of the areas where judges accumulate reserve judgments.
that is correct, JP.
Because in a week, if you are in that role, you are lucky if you get less than 12 opposed motion matters for that week.
That is correct,
Right.
JP.
The other area where you would generate reserve judgment is the special motion role. There, you've done 2 weeks there.
Yes,
That's also,
JP.
in fact, it's the most difficult because that has the most complex opposed motions, isn't it?
yes, JP.
Yeah. And then the other area, I see you've done 2 weeks of urgent court.
Yes, JP.
Yeah, and I can tell you and the commission, well, you know it. I don't easily put acting judges in the urgent court week because the Gauteng urgent court week, you need to smoke something to be allocated there.
Yes, JP.
Right. But I think, to be honest with you and the commission, having done 61 weeks, one would have expected you to do more work in that role, because you would have got familiar with the work of the division, seeing that you only were allocated to the last year to the urgent court week, having acted since 2020. But the fact that it's only 2 weeks should be something that you need to explain. I know I do the allocations, but as I say, I've explained to you that I need to have the confidence that the acting judge will deal with the work if I put them there.
JP,
Yeah.
the issue of the urgent court, as you say, you do the allocations, and in 2022, 2023, and this year, I think I started the urgent court last year and again this year. So that's the 2 weeks. I am available and I have been available. So I can't really answer it differently,
Yes.
but to say that I am available. Whether because your question somehow seems that you indicate you want to be confident in the people you put there. So I was of the view that that I would get more,
Yes.
but I didn't.
No, I'm not blaming you. I'm just saying it's my confidence. And I think partly the issues the CJ raised with you
Yes.
informed my decision why. Because
Understood.
in a normal urgent court week alone, there's 2 judges there alone, you are lucky to get less than 30 opposed urgent motions that week. Am I correct?
Correct.
Yeah. So it's a heavy work area.
Correct, JP.
Right. Now, that's the exposure you've had. So I want to tell you now, I have my own scoring metrics as to how I score candidates. So the allocations themselves and the work you've done I also will have to score you, but it will be informed by the number of weeks you've done in each particular week, especially the difficult work areas. You understand that?
Yes, Jay.
I want you to know that. Right? Now, let's come to the judgment you've written. You've listed 16 judgments. Check the list there in front of you.
Yes.
The reason I'm mentioning this is someone because we've got some of your competitors today who've acted probably half of the time you've acted, who've written a lot more judgments than that. Are you not shortchanging yourself here? I mean, you've acted for 61 weeks. You've done 7 weeks in the opposed motion court. That's a lot of work. Where are the other judgments?
Yes. JP, if I can just explain.
Yeah.
There are more than these judgments.
Yes.
There was a computer crash, my own, and you will recall in 2020,
Yes.
the case lines hadn't really started
In
2020. When at the beginning of 2020, some matters were on case lines and others not.
Yes.
And so when I was going through the judgments that should have been somewhere, you wouldn't find them on case lines.
Yes.
Because they weren't uploaded on case lines and we would have had the files. Same with opposed motion court in 2020. I would have had the files with me rather than on case lines. And what did help us post or during March is that, if I'm not sure, there was a directive that all matters would be on case lines. This is during the COVID period,
Yes.
which assisted us greatly.
Yeah. Okay. Look, I understand your explanation, but we give you a bench book, don't you?
Yes.
We give you a bench book, and that's where you record all the matters you hear, and if the matters were done in paper form, your bench book is the first go-to source to check which matters did I hear, where's the judgment, isn't it?
Yes, JP.
Yes.
I must indicate, in my first stint,
Yes.
I didn't take my bench book with me.
Okay. Okay. Now, let's come to your judgments. The CJ has already traversed that area. You know that my division is the first one to have had judges being disciplined for failure to reserve judgment. Do you agree with me that that is the overall primary existential basis for a judge to decide the matters that come before them?
I agree with you, Jake.
Yeah. So, don't you think, I think, let's just debate this. You are here, and I've actually been open-handed and give you acting stint. Do you think you could benefit some more if you are given more acting time, and then to see if these judgments that keep on cropping up and taking long to come out becomes a thing of the past?
Yes and no, if I can
Yes.
put it that way,
Yes.
JP. I'm not 50 anymore, and time is moving on.
Yes.
It is so that more time will be beneficial,
Yeah.
but that time as a judge also would be, and as I've indicated to the Chief Justice, that if given the opportunity, there would be great improvement in that area.
Yeah. So, as I indicated to you, I have my own scoring matrix that looks at particular areas. It's 4 areas. One is about judgments, one is about exposure, those 2. If I were to ask you sitting there, your performance in reserving judgments and in handing down judgments, out of 5, how much would you score yourself?
2.5.
2.5. Okay. Well, thank you very much. CJ, I'm done. Thank you.
Thank you, JP. I'm sorry, in the rush to start the proceedings, I forgot to welcome Judge President Tlaletsi, who represents the heads of court in Judge President Mlambo's place this morning, and Premier Lesufi, Gauteng Premier, who is here to make sure that we don't bring back judges to his courts. Good morning and welcome, JP and Premier. Premier, on that note, do you have any questions for the candidate?
Thank you so much, CJ. Truly appreciate. Thank you. Let me also greet fellow commissioners. Good morning, Advocate Ali.
Good morning, Premier.
Thanks. Just to belabor the point of allocating yourself 2.5 on outstanding judgment, is it lack of capacity or is lack of support?
Definitely not capacity, because capacity would mean that you are unable to come to, my understanding of, you are unable to come to grips with the matter that is before you. The support part is, as I indicated to the Chief Justice, is one of the areas, but shouldn't be the main area of justification.
The question is that I saw when you listed your experience and background in legal matters, you literally listed everything rather than the part of support that you're providing at the South African Secret Service. I assume it was also related to legal work, but I wonder why you didn't list it as part of the work that we've done that is related to law or legal work.
It's probably but it is contained in my CV. I'm not sure why at the present time I didn't list it then, but I did do legal work at the Secret Service also.
Thanks so much, CJ. Thanks.
Do you have questions, colleagues? JP Tlaletsi?
Thank you, Chief Justice. Mr. Ally, I just want some clarification from the answer that you gave to the Chief Justice regarding the fact that the GCB seems to have picked up more judgments outstanding than you disclosed. And the answer you gave is that you do not deny that, but you cannot remember them on top of your head. But later you said that you are working on them. Is that a fair understanding of what you said? And if that is the case, would you kindly explain that?
I thank you, JP Tlaletsi. When the question was posed, I said I do not deny it, and I said I am working on them. The two don't seem to marry when I think of it, you having posed the question.
I see. Thank you.
Yes, no.
Continue, sorry.
What I was meaning, if I had sight of them now, I could tell you they actually have been delivered or they haven't been delivered. And therefore I would be working on them. That's the best way I could explain it.
I see. And then my second question is, there is this problem of practitioners who are acting both in the high courts and the magistrates court, not delivering judgments either timeously or at all. Now, if you remove yourself from the fact that you could be one of those and look at things objectively, what advice would you give us to the heads of court and the JSC as to how to deal with this problem?
I think the issue has already started in the sense that my JP has started the ball rolling in respect of issues of this nature. And the more that one implements the policy, I would believe that down the line you'd get less and less deficiencies.
Do you see the LPC having any role to play in this regard, and what role can it play?
I'm not sure how, although the LPC can play a role when matters of that nature are reported to them. If memory serves me right, where acting judges are remiss or misconduct themselves, those matters would be reported to the LPC.
See. Well, I'm asking this also because you'll find that practitioners owe judgments, but they appear almost on a daily basis before the same courts in which they owe judgments, be it in the lower courts and the high court. And if I follow up on the suggestion that given a further acting stint would resolve the problem, will that not be tantamount to rewarding someone who's not able to deliver?
JP, it's not, you give the person the chance and further acting stint presents itself to improve that particular person. And that's the best way I would answer it.
And would you agree that you should also balance that against the interest of the litigants and the public in general?
Absolutely.
Whether not to expose them to such a situation.
Absolutely.
And make them guinea pigs in that regard.
I agree.
Thank you, Chief Justice. Thank you, Mr. Ali.
Thank you, JP. DP Zone.
Thank you, Chief Justice. Good morning, Advocate Ali.
Good morning, Commissioner.
I've just gone through your questionnaire. And more especially, I just want to refer you to page 9 of the paginated bundle. It's a section dealing with the court experience. Now, based on the information that we have provided in this questionnaire, surely it's difficult for one to assess your suitability, whether we could, at the conclusion of this session, recommend you. I'm not sure if, based on the information that you have provided, because you are marketing yourself, you should have given us more information that will sort of guide us in interviewing you. Would you agree with that statement?
I agree.
The other thing that concerns me, paragraph 6.2.4, labor law experience. You said as an assessor in the labor appeal court. I've sat in that court on a number of occasions, and we have never used the assessors. Where does it come from?
In the Eastern Cape, the Labour Appeal Court, if I could, I'm not sure of its citing. I was, Judge Kruan invited myself and Professor Grogan to assist in the appeal. I called it assessor because at the time, I was an assessor in the criminal courts and I was invited to assist Judge Kruan in one of the appeal matters he was dealing with.
Now, I'm not aware of that practice because we would do Johannesburg, Cape Town, Durban. I also did labor appeal court cases. I also sat on the labor appeal court cases in the Eastern Cape. So we have never used the assessor.
JP, I'm not sure whether the term could be described as correct, but I did preside with Judge Kruan. And this would have been around about 93, 94.
Unless maybe it was an industrial court, but not the labor court. Thank you. No further
Thank you.
question.
Thank you.
CJ.
Minister.
Thank you, CJ. Good morning, fellow commissioners, and good morning, Advocate Ali.
Good morning, Minister.
Thank you very much. I know CJ touched on the issues of outstanding judgments. I'm just finding it hard to be convinced on how you will improve given the reviews that have been outstanding and how you have handled them previously. It doesn't suffice to me to say I will definitely do them better. What is the plan that you have? I mean, for example, in the case of Alexandra, the one you say is still outstanding. It's a very painful matter, actually. It involves a minor child, and there's a long history in when the matter said, 3 times you have set deadlines for yourself. Even at the intervention of the Deputy Judge President, you committed that you will give a judgment on the 29th of March. You did not meet that deadline. The Office of the Deputy Judge President tried to intervene, and you undertook to finalize the same judgment on the 22nd of April 2024, which is a month later from the first commitment you made. You also did not meet that. And then the matter was escalated to the Judge President himself on the 3rd of July 2024. And you addressed the letters to the parties who are the attorneys and the family, the complainant, on behalf of the minor child. And you said the judgment will be dealt with on the 5th of July 2024. You are apologizing. You still did not meet this deadline. And today we are in October. We are still without this judgment, and you are saying to the commissioners here, you will improve on this matter. I think really right up to the office of the judge president, including the deputy judge president, this matter should have been resolved by now. At least it should have been finalized from your side. Do you have any comment there?
I can't comment further than what I have indicated, Minister. And I indicated to the Chief Justice when I would be finalizing, and I understand the frustration with that statement, taking into account what you have just read out. And I cannot put it any further than what I have, Minister.
So would you agree with me if I really question your commitment to the rule of law on the basis of all these chances you have been given? Look, this is a minor child with cerebral palsy. Rightly or wrongly, whether the case that has been put forth for the payment for future medical expenses. So a legitimate question will be, currently, what is the state of this child if we are unable to assist, at least from the handing down of the judgment? Do you think you have acted to the best of your ability in this matter, at least in trying to give justice to the minor child?
Minister, I don't want to justify the issue regarding when it will be delivered. In this matter, it's one that is somewhat different. There are matters that have been dealt with, and the ones that are outstanding now is dealing with the issue of the public health defense and so forth. So there are other medical expenses, and if I remember correctly, the hospital itself is providing, and the child still goes to that. But that doesn't take away the issue, Minister.
Thank you, Minister.
Yeah.
You may ask a follow-up question.
Just to end this quickly, who nominated you? Who nominated you for as a candidate?
I nominated myself.
Who accepted the nomination?
I just nominated.
You nominate? Okay.
I really don't.
No. Okay. Let me assist you this way. You nominated yourself, and then you accepted your own nomination. So, what is it that the advert requires that persons must be nominated? Did you read the advert?
Yes.
Does it not require that a person must be nominated for the position, rather than persons nominating themselves?
I'm not going to debate it, because the nomination doesn't say by whom.
No, I just want to...
But it is what it is, as it's there, and I can't take it any further than that.
No, just so that we don't go further with your interview. Look, correct yourself, correct me if I'm wrong. You are not supposed to be here because you have not been nominated. You are not supposed to even be here. Thank you, Chief Justice. I think at this stage we should end with your interview, but you can convince me that that's what I'm going to argue, that we are not supposed to be here.
Chief Justice, all I can say is I applied, there was the nomination, I was shortlisted, and that is why I'm here. I cannot say I'm not coming.
Yeah, the question is how, how did you get shortlisted?
Unfortunately, Chief Justice, I'm not in charge of that particular process. And I think it's a bit unfair.
No,
For-
I have no quibble with that. I'm not expecting you to answer that question. You did not shortlist yourself.
Yes.
But I'm just quipping myself because I did look at your nomination, and I did, because there's a consent. You nominate yourself, then you consent to the nomination. That's what I did not look closely at this because I saw your consent. And I completely missed that you were consenting to your own nomination of yourself. That's quite bizarre, to say the least. And anyway. Okay, Commissioner Kunyan, your hand was up first.
Good morning, Chief Justice. Good morning, fellow commissioners. Morning, Council Ali.
Morning, Commissioner.
Mine is one question only. You know for a fact, as Council, of the often quoted expression, justice denied, delayed is justice denied. Just for a second, remove yourself from that chair and put yourself in my chair. Would you be justified to recommend to the President the appointment of a person who has delayed justice, in dispensing justice, who has delayed dispensing justice for over a year? Would you do that? Would I be justified to do that?
Commissioner, it's difficult for me as the candidate to answer you regarding your prerogative. What I can indicate to you only is that on the objective facts before you, you will make your decision as to whether I am worthy of appointment to a permanent post as a judge.
Thank you, TJ.
I'm not happy with that answer, Advocate Ali. One of the hallmarks of a judge is impartiality. You should be able to divorce yourself from the fact that you are a candidate and give an honest answer to the question. You should be able to do that. And I'd like you to answer Commissioner Nkonyana's question honestly.
Chief Justice, what I was trying to impart was that there are judgments here and there are other judgments which obviously are not before you, which have been delivered on time. And I'm saying one must have a holistic view on what that particular candidate has done. Rightly so, there are those judgments which are factually correct, that they have been reserved for a long time, but there are others that have been delivered on time. And hence I was saying that one would look objectively and say, do you penalize for the whole or only for the part?
Chief Justice, perhaps to help, can you answer my question yes or no? That's it. That's what I want. I heard your explanation, and you have tried to explain before. All I want, would you do it yes or no? That's it.
Chief Justice, I find it difficult to answer the question yes or no, having given an explanation. You asked me to explain, and I
It's all right if
explained.
you're struggling with doing what he's asking of you. We can move on. Commissioner Lekhanyan?
No, Chief Justice, just to make a follow-up on the questions that were asked by Commissioner Simelan, Commissioner Minister, and Commissioner Premier. I want to refer you to Section 28 of the Constitution, which is contained in the Bill of Rights, which speaks on the rights of children and related national legislation. And you can also include other international conventions. Where you stand as a candidate, do you think that what the minister asked you about a minor who has a specific health condition, doesn't that constitute a violation of the rights of children or substantial injustice on the part of that child? Having delayed that judgment for over a year, what is your judgment on that matter? If we have to make a judgment on your failure, what becomes your judgment? Doesn't that constitute gross violation or substantial injustice?
I can indicate to you, Commissioner, as I indicated to the Minister, the nuance in respect of this case. And I would answer yes and no to your question.
Your answer is yes and no.
Yes, because of the explanation.
Okay. Let's leave it there. If you were one of the drafters of the Constitution of the Republic of South Africa, why would you think that the drafters allocated themselves ample time to decide that the rights of children must be included in the Constitution?
Commissioner, the rights of the children being included in the Constitution speaks to the vulnerability of that of those or that section of the population, and needs protection.
Okay. The last would be what Commissioner Lesufi has asked, whether the problem on your part is with regard to capacity or lack of support. And you have been asked several times here, you are unable to come clearly before this commission to say, I have 20 outstanding judgments and I'm planning to deliver 16 of them on the following days or in this period. And the remaining number will be delivered in the period that will follow. You have been very dithering and very reluctant to respond to this question. Just to give the exact, a judge, remember, a judge is not an ordinary person in society. You cannot behave yourself like a person who has not seen the inside of a book. You have to be very honest with us if you think that you are a fit and proper person for these positions that have been advertised to. Tell the Chief Justice or the JP, who are your supervisors? How many outstanding judgments are there? And what is your plan to deal with them? If you can't account to your supervisors, must we call you before Parliament to come and account before Parliament? When your immediate supervisors are here, they want answers from you. Why aren't you giving them those answers? How many outstanding judgments do you have, and what is your plan to deliver them?
Commissioner, when answering the Chief Justice in relation to the one matter, I indicated when I would be doing that. In respect of the others, which I indicated, off the top of my head, I don't have, I can't indicate to you the number off the top of my head. But I indicated to the Chief Justice that I am working on them. And in respect of your specific question as to when those would be delivered, I would indicate the timeline of end of November.
No, I did not want to be hard with you earlier, but I have to mention to you that from my experience, and I know that I speak for all judges, nothing is as heavy, as burdensome as a reserve judgment. It haunts you until you have delivered it. It is extremely worrisome that you can't even remember. You say you are working on them, but you don't have any detail. You can't remember. You can't give us any detail on these judgments you're supposedly writing now. I find that strange. I find that very, very strange. Do you have a comment?
Chief Justice, as I indicated, the ones that were in here, that the one is outstanding in the
yes,
questionnaire.
you have, and you've given an undertaking to deliver it by the end of October. But we're talking about this, the at least 3 that the General Counsel of the Bar has mentioned.
And what I was indicating to you, Chief Justice, is at present I don't see the judgments that they're indicating, and I'm indicating that they could have been delivered already, but that was my only reservation with the 3 that you had mentioned that the General Counsel of the Bar had mentioned.
But then you had said you don't deny that there are such outstanding judgments, that is the problem.
Yes, Chief Justice.
So what do you mean you don't deny that there are such outstanding judgments, and then in the same breath, they could have been delivered?
Yes, I understand. I should just remain with my answer that
Which is?
which I had given you previously, that I am working on them. Because you can't have both answers.
All right. Commissioner Hassan? Where did she go? Any questions? Commissioner Gotzel.
Thank you, Chief Justice. Good morning, Advocate Ali.
Good morning, Commissioner.
With reference to news reports that civil claims in Gauteng's courts might only be heard in 2028, it was recently reported that legal professionals are at their wits' end over the longest backlog in history. Now, in your view, what is a judge's role in ensuring expedience in the administration of justice? And I don't want you to go back to reserve judgments. This is a general question.
The statement of the backlog, in my view, doesn't speak to the expedience of the court, because the expedience of the court is about how many matters come before that particular division. And are you able to have your matter heard? That is one issue completely, and which is different from the judgments that are reserved after the matters have been heard. As I see it, the backlog is that claimants or litigants are not able to get to court because of the backlog. Not that they have not had judgments on matters. I'm not sure if I explained the issue, because when you read out the backlog, then you asked about the expediency.
No,
Leaving out reserve judgments, you said.
yeah, and I think you misunderstand me. My question is, what is a judge's role in ensuring the expedience in the administration of judges? I understand what you're saying, but there are obviously many factors that contribute to a delayed court roll. But what could you do as a judge to assist that problem?
Well, I know in the Gauteng Division, in Johannesburg and Pretoria, there's meetings upon meetings regarding how we can get the backlog down. And I think the JP answered in the media also that we have pro bono counsel and attorneys that have been taking it upon themselves to make themselves available so that matters can be cleared. And I think that is a good initiative.
Thank you.
Are there any questions from the virtual platform?
Thank you very much, CJ. Good morning, Advocate Ali.
Good morning, Commissioner.
I want to traverse a different line of questioning with you. As you know, that Gauteng is the place where usually the state will be sued, and some of the state departments will be sued on the basis of administrative law. I just want to ask you this question. Should you be successful, you will be expected to have a good grasp of administrative law generally. My question to you is, can an organ of state utilize the provisions or utilize PAJA generally for the purposes of reviewing and setting aside its own decision?
Can you just repeat the last part? I think there was a distortion at the end.
All right, let me repeat the whole thing. Can an organ of state utilize the provisions of PAJA for the purposes of reviewing and setting aside its own decision.
My answer would be yes, that they would approach the court to have a decision set aside on the basis of the unlawfulness of that decision.
No, well, the answer seems to be contrary to what the Constitutional Court said in State Information Technology. Let me ask a different question. What is the difference, if any, between a review process under PAJA and a review process under the principle of legality?
The review process under PAJA is dealt with in terms of Section 6, memory serves me right, and deals with the processes that would be against the administration of justice. The issue of legality is dealt with more constitutionally in terms of what decision has been taken, whether that particular person has traversed the rule of law in coming to that decision.
Well, I have difficulty understanding that, Advocate Ali, but I will leave it there, CJ. Thank you very much.
Thank you, Prof. Thank you very much, Advocate Ali. We've reached the end of your interview.
Thank you, Chief Justice.